No member of the United States Supreme Court has ever appeared clearly to break the law until now.
This is an astute PR move, that's all it is.
It feels like it's a joke.
An updated ethics code with no means to enforce it still leaves a gaping hole for mischief.
The U.S. Supreme Court has established an ethics code for the first time in the court's history. This, despite the fact that every other judge in the country, plus all federal employees and elected officials, must operate under an enforceable code of conduct. For centuries, the Supreme Court has been above the law, but recent revelations about million-dollar excursions and shady friendships with billionaires have plummeted public trust in the Supreme Court, an institution that traditionally experiences higher public approval ratings than the other branches of government, specifically because of the dedication to at least seeming impartial and unswayed by money or politics. In response to this loss of trust and public scrutiny of the court's ethical practices, all 9 justices signed onto and released their self-written code of ethics last month. Instead of persuading the public that the code will increase accountability and impartiality in the court, it merely reinforces that all the sketchy things you think you saw those justices doing? Perfectly ethical. Nothing to see here. This is why the new Supreme Court Ethics Code is even worse than you think. Roll the intro. Thank you to my partner on today's video, Factor. Factor is a super easy and delicious meal delivery service that delivers fresh, never frozen meals straight to your doorstep. So handy. I love them. Truly, I've never found a more flavorful, delicious, and satisfying meal that is so easy to prepare and eat. Just 2 minutes in the microwave and it's hot and ready to go. And right now it's the holiday season. I'm eating a lot of food that makes me feel not really great, like too much sugar, too much alcohol, and I'm really busy. So it feels really great to be able to just reach into the fridge and grab a meal that I know will have vegetables and protein and great flavor, even if I'm crunched for time. Today, I tried their garlic and herb chicken breast with smoked cheddar cauliflower grits and a side of broccoli, and it was so delicious and quick and easy that I literally ate the entire thing before I remembered to film it. Sorry. They also have other amazing dishes like Indian butter chicken and loaded bacon cheddar chicken, and tons of other meals to choose from, including over 35 different meals every week, plus vegetarian, protein plus, and other diet-specific options. So this holiday season, enjoy eating well without the hassle thanks to Factor. Head to factor75.com or click the link below and use code Leeja50 to get 50% off your first Factor box. Thanks, Factor. The most recent calls for a Supreme Court code of ethics have been in response to an increasingly political court, as well as revelations that both Justices Thomas and Alito have received lavish gifts in the form of travels on yachts and private planes to exotic places with incredibly wealthy friends who footed the bill, which was often in the hundreds of thousands of dollars. And those wealthy friends had financial interests in matters coming before the court, and none of these gifts were disclosed. When confronted about the wealthy benefactors and their expensive gifts, both justices claimed they didn't believe that they were in the wrong. And while these lavish trips made splashy headlines that caught all our attention, these are not the only incidents in which Supreme Court justices took ethically dubious actions, including some that may not technically violate any laws or codes, but certainly seem questionable enough that a judge of that stature should have at least considered how it would reflect on their ability to remain neutral and how it could erode public trust in the court generally. Before we dive into a list of the ethically dubious things our current justices have done, I wanted to give you an idea of the types of ethics rules that govern lower court judges and lawyers and elected and government officials, just to give you an idea of how insane it is that the Supreme Court answers to no one when it comes to ethical quandaries. The Judicial Conference adopted a code of conduct for United States judges back in 1973, which has been updated frequently since then and applies to all federal judges except the Supreme Court. Central to this code is the idea that judges have a duty, because of their position and the importance of maintaining an independent and honorable judiciary, to act with integrity and to avoid any situations which would lead the public to question the judge's ability to provide impartial, just, and even-keeled rulings. The code makes this clear, saying, deference to the judgments and rulings of courts depends on public confidence in the integrity and independence of judges. The integrity and independence of judges depend, in turn, on their acting without fear or favor. Although judges should be independent, they must comply with the law and should comply with this code. Adherence to this responsibility helps to maintain public confidence in the impartiality of the judiciary. Conversely, violation of this code diminishes public confidence in the judiciary and injures our system of government under law. The code specifically requires that judges should not use the prestige of their office to advance the private interests of anyone, not themselves, their family, or anyone else. The code's commentary states, "A judge must avoid all impropriety and appearance of impropriety. This prohibition applies to both professional and personal conduct. A judge must expect to be the subject of constant public scrutiny and accept freely and willingly restrictions that might be viewed as burdensome by the ordinary citizen." When you agree to become a judge, in exchange for that prestige and that position of influence, you have to give up some freedoms and some activities you normally do. It just comes with the territory. The code goes on to say, "A judge should be faithful to and maintain professional competence in the law and should not be swayed by partisan interests, public clamor, or fear of criticism." Further, a judge should not initiate or consider communications concerning a pending or impending matter that are made outside the presence of the parties or their lawyers. An important part of the code regards when a judge should disqualify themselves or recuse themselves from hearing a case. The code says, "A judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to instances in which," and then lists a number of instances, including where the judge has personal bias or prejudice concerning a party, has served as a lawyer on the matter coming before them, or previously practiced law with a lawyer before them, if the judge or their spouse has a financial interest in the case, or any other interest that could be substantially affected by the outcome of the proceeding. According to the code, it's the judge's duty to keep informed about their personal and financial interests, as well as those of the judge's spouse and others residing in the judge's household. Further, the judge shouldn't participate in fundraising activities, or solicit funds for organizations, or use the prestige of their judicial office to help raise funds. And under the Judicial Conduct and Disability Act of 1980, any person can file a complaint alleging a federal judge has broken the code of ethics, which will then be reviewed by the circuit chief judge, and a report is reviewed by the Federal Judicial Council, which then issues an order that could lead to censure, suspension, or removal. Though anything more than a slap on the wrist via a reprimand is incredibly rare, but there's at least an enforcement mechanism. Similarly, lawyers have a code of ethics that they must adhere to or face disbarment. In fact, we're required to take a class on it and pass a special standardized test on legal ethics before we're even allowed to sit for the bar. Each state has its own ethics code, but they all generally follow the American Bar Association's model rules of professional conduct. The rules are pretty dense, but a lot of them have to do with establishing trust between lawyer and client, which involves requirements about communicating the exact scope of the lawyer's representation of the client, never giving out legal advice unless the person or entity is your client and understands the scope of representation, and you as the lawyer understand the scope of the problem so you can give them legal advice that is as accurate as possible. That's why I can't come on here and do a Q&A and answer all your personal legal questions. That would be ethically irresponsible of me because we haven't established an attorney-client relationship, and I don't have enough background knowledge of your case to give you a one-off answer on the internet. This is also why most lawyers include disclaimers on their social media confirming that they aren't your lawyer and this isn't legal advice, because it's required in our ethics code to make sure you know the extent or non-existence of our relationship, which, to be clear, I'm not your lawyer. Got it? Great. The Lawyer Ethics Code also includes attorney-client privilege, so making sure that they are actually your client, and then, once they are, ensuring that everything they say stays between the two of you. A lawyer also can't solicit any substantial gifts from clients. Another important aspect of lawyers' ethics rules involves conflicts of interest. A lawyer can't represent a client if representing that client would be directly adverse to another client. For example, if you have a client who's suing a party, and then that party comes to you for a different matter and asks for your representation, you can't represent them because you're actively suing them in a separate matter. It would be a conflict to your current client's interests. Lawyers also can't represent clients if there is a significant risk that their ability to represent the client will be limited by the lawyer's responsibilities to another client, to a former client, or by a personal interest of the lawyer. Lawyers are also barred from entering into business relationships with clients or acquiring financial interests that would be adverse to that client. So like buying a stake in a company that the lawyer is actively suing on behalf of a client, not a good idea. And the profession takes conflicts of interest so seriously that it is standard practice in pretty much every firm in every state that any time a prospective client comes to their door, they have a standard procedure for running a conflicts check, which means looking through their list of previous clients and adversaries, keeping stock of personal and financial interests of yourself and your family members, and ensuring that there are no existing conflicts of interest with the prospective client before agreeing to take them on. In large firms, there are entire databases and specific people who are required to go through those databases before you can take on a client. Similarly, for elected and government officials, there are laws that govern their ethics and conflicts of interest. They're prohibited from participating in official matters that affect the financial interests of themselves, their spouses, or members of their household, or organizations in which they serve as officer, trustee, partner, or employee. Higher-level officials are required to submit financial disclosures annually. Presidential appointees in the Justice Department are banned from receiving any outside income other than investments and royalties. They cannot receive compensation for speaking, writing, or teaching that relates to their duties. They may not engage in fundraising in their official capacity. No employee may use their official position or influence to interfere with an election. Most federal employees cannot accept gifts valued at more than $50 per year, including senators, representatives, and their staffers. Even the President of the United States and his family are required to publicly disclose gifts exceeding $260 in value. Okay, so now that you know generally the ethical expectations for those serving as lawyers, judges, and government officials in virtually every level and branch of government, let's talk about the Supreme Court. The Supreme Court has none of that. Before last month, they had never had a written code of ethics. Certain laws require that they make regular financial disclosure statements, but that's about it, which is nuts compared to the requirements of all these other similarly situated professionals. And it's not because they didn't need one. Our history is rife with Supreme Court justices doing ethically dubious things. There's a reason that we're calling for a code of ethics now. Public trust in the court is at an all-time low, which is the exact thing that an ethics code is meant to prevent, so that judges are held to some level of standards that require them to act impartial and unbiased. And the Supreme Court has been doing a shitty job of that lately. So let's go over a brief list of all the ethically dubious things our justices have done recently, shall we? Luckily, the nonprofit Fix the Court keeps a handy-dandy running list for us to consult. Let's take a look. Chief Justice John Roberts has, on multiple occasions, failed to recuse himself from cases, meaning refrain from hearing oral arguments or participating in judicial decision-making in cases where the Chief Justice actively owned and traded in stocks in one of the parties involved or in the party's parent company. Justice Clarence Thomas has truly an impressive laundry list of ethically questionable acts, not least of which being those lavish trips I mentioned, paid for by financier Harlan Crow. Crow also gave Thomas a Bible that was once owned by Frederick Douglass, valued at $19,000, and he donated $500,000 to help Ginny Thomas, Justice Thomas's wife, establish Liberty Consulting, which she then used to lobby against laws like Obamacare, which then of course came before the court on multiple occasions as conservatives tried to chip away at the Affordable Care Act. Conservatives like Ginny Thomas and her Liberty Consulting lobbying firm, and Justice Thomas never recused himself from hearing those cases, despite significant personal and financial interests of his wife in a certain outcome for each of those cases. He also attended a Koch Industries-backed luxury retreat in Palm Springs at a time when Koch Industries was bankrolling several litigants in cases before the Supreme Court. His name was used in promotional materials to sell tickets to the NRA's National Youth Education Summit, at which Ginny Thomas was planning to speak. The summit lineup included exciting question and answer discussions with the wife of Supreme Court Justice Clarence Thomas. He also conveniently forgot to provide mandatory disclosure of 5 years of Ginny Thomas's employment, during which time she earned $686,000 from the Heritage Foundation. Yes, the Heritage Foundation, the one that is promoting Project 2025 to dismantle the government if a Republican wins the presidency in next year's election. That place. He attended the annual Eagle Forum conference in 2017. The Eagle Forum is a conservative interest group founded by Queen anti-feminist Phyllis Schlafly. At $350 a plate, this conference likely raised funds for the Eagle Forum, and Ginny Thomas used her husband's appearance to help sell tickets. He prominently displays a picture of himself swearing in Mike Pence, signed by Mike Pence, in his court chambers. He failed to recuse himself from any of the 2020 election fraud cases, despite the incredibly public nature of his wife's clear interest in overturning the election results, including publicly released text messages, social media, and listserv posts showing she was actively working with high-level Trump officials to try to subvert the election results. But now, Clarence, he's perfectly capable of being impartial. There have been reports that he was in contact with Ron DeSantis, governor of Florida, around the time Florida was to appear before the court in an anti-vax case. And he posed for a photo inside the Supreme Court building with Herschel Walker, you know, the Senate candidate from Georgia credibly accused of multiple cases of assault. Yeah, he posed with him for a picture 7 weeks before Walker's primary election, which was then posted on social media by Walker's campaign director. And that's just to name a few. Let's move on. Justice Stephen Breyer also has a history of not recusing himself from cases despite actively owning stocks in the parties or their parent companies. He also has been in attendance at high-priced fundraising events. Justice Samuel Alito also has a history of not recusing himself from cases despite actively owning stocks in the parties or their parent companies. He, along with Justice Brett Kavanaugh, met with the head of the National Organization for Marriage inside the Supreme Court while that organization had filed multiple amicus briefs in cases actively pending before the court. He also attended Secretary of State Mike Pompeo's taxpayer-funded Madison dinner, along with other GOP politicians and donors. He gave a speech at the Federalist Society annual convention, which included discussing COVID's impact on religious exercise, even though there were cases concerning that very topic actively pending before the court. The Federalist Society, for the unfamiliar, is a conservative and libertarian legal organization that advocates for a textualist and originalist interpretation of the U.S. Constitution. It's co-chaired by Leonard Leo, who has his hands in all sorts of sketchy stuff, not least of which was in drafting the list and advising Trump on who to nominate for the Supreme Court. He also helped pick or confirm Justices Thomas, Roberts, and Alito, so the chair of the Federalist Society has had a hand in the selection and/or confirmation of, let's count that, 6 of the 9 current justices on the bench, all the conservatives, and Alito was there giving speeches. Awesome. Justice Sotomayor failed to recuse herself from a case involving her own book publisher, Random House, despite the fact that the publisher's appearance before the court happened just a few months after it had spent tens of thousands of dollars on her book tour. Sotomayor has made millions off her book sales. She also took months to recuse herself from a case in which one of the parties was a close friend of hers. Justice Kagan was the U.S. Solicitor General in the White House before becoming a Supreme Court justice. During that time, she actively worked on the legal defense for the Affordable Care Act. Despite this, she never recused herself from cases involving the ACA. And there were numerous other times where she either took months or completely failed to recuse herself from other cases that she actively worked on as the U.S. Solicitor General. She's also given speeches at fundraising events. Justice Gorsuch gave a talk at Trump International Hotel in Washington to a group called the Fund for American Studies, which is an associate member of the State Policy Network. We talked about the State Policy Network in my video on the Heritage Foundation. They're a collection of conservative state-based nonprofits that are being spoon-fed Heritage Foundation and other national organizations' policy points to help enact a uniform conservative agenda at the local level all across the country. A different member of that same State Policy Network was representing a party in a case actively pending before the court when Justice Gorsuch gave that talk at the Trump International Hotel. Gorsuch also failed to recuse himself from a case involving his own book publisher, and he spoke at a Florida Federalist Society event that barred the press from attendance and included other appearances by the likes of Ron DeSantis and Mike Pence. Justice Brett Kavanaugh hasn't had as much time to do ethically questionable things while on the Supreme Court bench, though there are the numerous confirmed instances when he lied under oath before he took the bench, but I guess we'll let those slide. Justice Barrett also hasn't had much time to do the ethically dubious, but Americans for Prosperity spent more than $1 million to help get Barrett firmed, and she did not recuse herself when they came before the court in Americans for Prosperity Foundation versus Bonta. She also gave a speech at the McConnell Center at the University of Louisville, and while physically standing next to human turd Mitch McConnell inside the McConnell Center, she urged the public not to view the court as political. And before that speech, which was closed to the public, she joined McConnell and 12 to 15 of his friends for a private dinner. And there are also recorded instances of questionable things recently done by those no longer on the court, including Ruth Bader Ginsburg. Yes, this is why we can't have heroes. In 2006, when Senator Grassley proposed the creation of a Judiciary Inspector General's office to oversee ethics violations of the Supreme Court, she compared the proposal to Stalinism, saying oversight like that is a really scary idea that sounds like the Soviet Union. She frequently made public statements about laws and politicians, including a Texas abortion law that appeared before the Supreme Court, and she didn't recuse herself. She called candidate Trump a faker with an ego on CNN, and later said, "Imagine what the country would be like with Donald Trump as our president," in an interview with the New York Times. And listen, she was right. But also, we have an incredibly famous and influential Supreme Court justice making public statements about a person actively running for president. You know? She also performed a same-sex marriage while 𝗬𝗥𝗢𝗥𝗧𝗏, the case that made it legal nationwide, was actively pending before the court. Again, iconic, but like, at what cost, you know? The problem that I think a lot of justices face is that they were advocates and activists before they took the bench. And in agreeing to become a judge, especially a justice on the Supreme Court, you have to step away from that activism in order to keep greater faith in the public image of the court. And not all of these actions actively violate the law or even necessarily the code of ethics that lower court judges are held to. But each one serves to undermine public trust in the court's ability to be apolitical, unswayed by public interests, and capable of providing an unbiased ruling on what the law and the Constitution says. Whether they're using their position to enrich themselves on book deals, speaking at events held by clearly political organizations, helping those organizations raise money off the backs of the justices' prestige, or failing to remove themselves from cases where they or their family members have personal or financial interests in the outcome of the case. And each act by itself may not amount to much, but over time they pile up to the point where it's hard to hold the justices in high regard because their actions have, on the whole, been incredibly suspicious, or at the very least thoughtless, which isn't a good look for a Supreme Court justice. And they know that their legitimacy is under threat because of this, so they're going on speaking tours to convince the public they're still not political and legitimate, which, first of all, if you have to do that, you've already lost. Saying, you guys, I'm really legit, is the surest way to make people suspicious of you. But also, they're doing these speaking gigs at the Mitch McConnell Center and the Federalist Society. Like, they're not even trying to make their actions match their words. And they know that that's not working, and so to stave off Congress taking the action it needs to take in creating an enforceable ethics code on the Supreme Court, they said, no, we get it, we'll draft our own. Because the surest way to avoid responsibility is to write your own regulations. And now, thanks to this new ethics code they just released, they're off the hook. Because frankly, it's written in such a way that it looks good and solid, but it actually excuses nearly all of the behavior that I just listed. And they make that clear in the very first paragraph of the introductory statement to the Code of Ethics. They say, for the most part, these rules and principles are not new. The court has long had the equivalent of common law ethics rules, that is, a body of rules derived from a variety of sources, including statutory provisions, the code that applies to other members of the federal judiciary, ethics advisory opinions issued by the Judicial Conference Committee on Codes of Conduct, and historic practice. The absence of a code, however, has led in recent years to the misunderstanding that the justices of this court, unlike all other jurists in this country, regard themselves as unrestricted by any ethics rules. To dispel this misunderstanding, we're issuing this code, which largely represents a codification of principles that we have long regarded as governing our conduct. So they're doing this to cover their asses. They're saying, no, we've always had ethics rules that we've followed. We're just writing them down here for you, the stupid idiot public, so that you can see what we've clearly always been following. Because it seems that there's been some misunderstanding. It seems there's been some confusion on your part. So we're writing this down for the benefit of the public so they can see what we've always known and done, not to hold ourselves to different or any higher standards. Cute. Great way to start. And much of the new Supreme Court Ethics Code follows the code laid out for other lower court justices. But there are some subtle changes that say a lot about the fact that Supreme Court justices still consider themselves above the law. For example, in the Ethics Code for lower court judges, in the section related to recusal, the language says, a judge shall disqualify himself or herself on a proceeding in which the judge's impartiality might reasonably be questioned. In the Supreme Court Code, they've changed that to say, a justice should disqualify himself or herself in a proceeding in which the justice's impartiality might reasonably be questioned. And you might think that's semantics, but we're talking about a group of 9 people whose job it is to squabble over the meaning of single words in the Constitution or in the laws. They understand the weight that a single word can have. And in the law, there is a big difference between shall and should. Shall is akin to will, must. Should is weaker. It's a suggestion. And they know this. So when their code gently suggests that they should disqualify themselves if they have a personal bias concerning a party, or they or their family member has a financial interest or a personal interest that could be substantially affected by the outcome of the proceeding, that's a recommendation, not a requirement. If they don't do it, technically in violation. It's much easier to argue away a should than a shall. They also note that neither the filing of a brief amicus curiae nor the participation of counsel for amicus curiae requires a justice's disqualification. And this is important because many objections against actions taken by Supreme Court justices that seem unethical stem from ex parte communications between the justices and amicus parties. And let me break down what that all means. So in a case before the Supreme Court, the parties submit their briefs containing their legal arguments. And then other outside parties who have interests in the outcome of the case but aren't named parties in the case can submit what are called amicus curiae briefs. That means friend of the court. So it's providing the court with additional background information to help the court make their decision. This can be helpful for the justices, but they're under no obligation to read these outside briefs or apply them. But sometimes these briefs are filed by the Federalist Society, or the Heritage Foundation, or Koch Industries. And when you're personal friends with members of those organizations, when those organizations have given you lavish gifts or held dinners in your honor, when you meet with them outside the earshot of the parties and their lawyers, like how Kavanaugh and Alito met with the National Organization for Marriage while they had interests in the outcomes of cases pending before the Supreme Court and had submitted amicus briefs in those cases, that doesn't look great. That still erodes trust in the justice's ability to remain neutral. But under this new code, that's kosher, baby. And there are numerous other carve-outs in the code that make it clear the justices have no intention of changing their ways. It says, in deciding whether to speak or appear before any group, a justice should consider whether doing so would create an appearance of impropriety in the minds of reasonable members of the public. Except in unusual circumstances, no such appearance will be created when a justice speaks to a group of students or any other group associated with an educational institution, a bar group, a religious group, or a nonpartisan scholarly or cultural group. So they can speak at religious groups. Great, no limitation there. Definitely, if justices start exclusively talking at conservative Christian megachurches, that won't create any appearance of impropriety. They can also speak at nonpartisan cultural groups. Interesting. Would the NRA fall under that? I don't see any party association listed on their website. I think many would argue that gun ownership is their culture. Seems fine. Speaking at Hillsdale College, an accredited institution, would also be fine under this code, despite the fact that the college is known to be a far-right conservative incubator. And many of these carve-outs are specifically about the justices being able to continue their speaking careers, publish their books, trade in stocks, lend prestige to nonprofit legal and social organizations, and continue enriching themselves and wielding their influence on the back of their prestige as Supreme Court justices, all while patting themselves on the back for being ethically sound and above reproach. And I think for me, the thing that stuck out the most was how much these carve-outs are incredibly out of touch with how most of us live our lives. That they need to carve out special allowances for justices to own individual stocks and property, sit on boards, and act as trustees. It's indicative of how out of touch they are. It's the same vibe that scene from Arrested Development. It's one banana, Michael. What could it cost? $10?
I mean, it's one banana, Michael. What could it cost? $10?
It's them saying, well, of course we own individual stocks and companies. Of course we write books and sit on boards and act as trustees. We need protections to be able to continue to enrich ourselves while sitting on the bench. They believe so strongly in that they wrote numerous specific carve-outs in their own code of ethics for all of it, completely losing sight of the reason for the code to begin with. Average everyday Americans, the ones who aren't in the 1% rubbing elbows with the Supreme Court justices, are losing faith in our justice system. And we're losing faith in a court whose decisions have very real, very tangible effects on very foundational parts of our lives. Who we can marry, how we procreate. This new code makes very clear that their heads are so far up their own asses that we don't even occur to them. This isn't a code to help us have more faith in them. This is a code to help themselves sleep better at night. And this is made abundantly clear by the fact that the code has absolutely zero consequences or enforcement mechanisms. There is no way for anyone to hold them accountable. The code rests enforcement of its provisions in the justices themselves. So when the code says, for example, a justice should disqualify him or herself in a proceeding in which the justice's impartiality might reasonably be questioned, that is, where an unbiased and reasonable person who is aware of all relevant circumstances would doubt that the justice could fairly discharge his or her duties. That means that the justices themselves are the ones who decide who a reasonable person is in this scenario, and what is reasonable to believe and feel about their connection to the case. So when someone says, hey, don't you own stock in that party's parent company? A justice can decide, yes, but you thinking that I can't make an unbiased decision in this case despite that financial interest is unreasonable. Therefore, I don't need to recuse myself. And given what they've demonstrated about how out of touch they are, who are they to decide who's reasonable? In a traditional court case, where it has to be determined what qualifies as reasonable, that's usually a question left for a jury to decide. This code is like saying to a defendant in that case, hey, do you think that you are being reasonable and therefore shouldn't be found liable here? We don't do that, because defendants can't determine for themselves whether or not they were being reasonable. They would say they were being reasonable 100% of the time. It doesn't make any sense. Why are we holding the highest court in the land to lower standards than we hold everyday defendants in every court across the country? Make it make sense. This is why people are calling on Congress to put reforms in place that provide an ethics code that's actually enforceable, either through an independent council like the one that reviews complaints from all lower court judges, or through Congress itself. Some argue, including some of the justices themselves, that Congress doesn't have the constitutional authority to regulate the Supreme Court in this way because of the separation of powers, and because the Constitution created the Supreme Court and only gave Congress the ability to create lower courts. However, many argue this is a mischaracterization of separation of powers in the Constitution. Separation of powers has never meant that each branch can never regulate the others. Checks and balances are inherent in that separation of powers. It's why the Supreme Court can overturn Congress's laws, and why the president can issue executive orders. The Constitution itself gives Congress the right to impeach not only the president, but also Supreme Court justices. The president has the right to name new justices, and the Senate has the right to oversee the confirmation of new justices. And Congress has regulated the Supreme Court in other ways, including through the creation of a written oath that justices must take when being sworn in, and setting the number of justices and how they're compensated. They've also required Supreme Court justices to make financial disclosures regularly. So to say Congress doesn't have the authority to regulate the Supreme Court in this way doesn't really square with the history of Congress's relationship with the Supreme Court, or even what the Constitution says. Last summer, a law was introduced in the Senate that would require the justices to adopt a code of conduct approved by the Senate Judiciary Committee. It was heavily supported by Democrats, but Republicans wrote it off as nothing more than Democrats trying to exact control over a conservative majority court. Despite the fact that, again, this is about a court that makes important decisions that affect deeply personal aspects of our lives, but most of us don't trust most of the judges on the bench. That's not a partisan issue. It's an issue of faith in our government and our justice system, which has been steadily eroding in recent years. An ethics code that holds our most powerful judges accountable and exacts high ethical standards, overseen by an external nonpartisan group, is one small step towards fixing that trust. And if you liked this video, you'll also like my video on whether the US is a democracy or whether it's a republic. Hint, it's neither. And hey, if you didn't know, my work in bringing you these videos week after week, which collectively take 25 to 30 hours each to make, is supported in part through my Patreon, where I do weekly chats on our private Discord server, book giveaways, early access to videos, access to my research notes, and monthly Ask Me Anything style live streams, just for my Patreon supporters. If you like what you've been watching and any of that sounds good to you, I encourage you to come on over to Patreon today. Thank you to my Patreon supporters, including my newest patrons, and an extra special shout out to my multi-platinum patrons, Thomas Johnson, Sophia Sams, Anthony Giles, and Brett Piontek. Thanks so much for watching. Have a good day. Bye-bye!